Chairman Darby.
Dr. Field, thank you. Excuse me. Dr. Field, thank you for coming today. Your testimony is invaluable to us. First of all, the name shaken baby syndrome. To me, that connotes guilt on the face of the charge. If you've been charged with shaken baby syndrome, it would indicate to me, at least, that somebody shook that baby to death. And since you were the last person to be near that child, that you were therefore guilty by simply being charged with the name. What are your thoughts on that? Whether psychologically to a jury, just being charged with shaken baby syndrome would indicate in the jury's mind that there was a crime committed, that you've now said perhaps was no crime. What are your thoughts on that?
Well, I think you're exactly right, Representative Darby. In psychology, we refer to something called iatrogenic label, where the label itself creates more problems than what it describes, and that is a very toxic label, obviously, and that's why I say I think sometimes burden of proof is a myth. When a jury hears something like that, they go, wow, if that's not what we're down here for, we have a dead child, and they're pointing fingers over here at this guy who doesn't seem to be terribly sensitive or upset, and if we're not down here for that, somebody needs to give me a really good alternative explanation, because they're looking over here. It's just like this setup right here. You got that big state seal up there and those flags beside it, and you got armed guards over here and all, and there's an awful lot of entrapments to this situation, trappings to this situation that make it seem awfully official. And then you got this guy over here, and the prosecutor knows the judge, and the judge knows the prosecutor, and they're calling each other by name, and the court clerk, and all is like, "Hi Betty, how are you today?" And it's like everything seems against the guy that's there for the first time ever, and so there's a lot of momentum here. Somebody better have a really good alternative explanation, and there was a really good alternative explanation. The only flaw was it never got mentioned. It never got told, which is why I made the point that jurors make decisions on what they see and hear, not on what they don't see and hear. All of this that I talked about today never got into the court record. It never got reported. Nobody ever put all those pieces together until 18 years later, when the Innocence Project with pro bono lawyers and all come along and start piecing it together, and then they come to me, and I have my whole team at Merit TV, and everybody starts coming together, and now all of a sudden you have a valid defense team, and now you get an alternative explanation.
Well, I made a statement before you came into the chamber here, but the purpose of this body and committee, in my opinion, today, is to examine our current law that's on record that we created. There was a problem when convicted people could not get their matter heard on appeal because there was not an avenue created by the legislature. We created it. And so in 2013, we addressed that deficiency. I'm going to be a kind of a long question, but if you'll bear with me. We said that specific facts must be available that indicate relevant scientific evidence was currently available and was not available at the time of the conviction because the evidence was not discernible through reasonable diligence at the time of the trial, and the scientific evidence would be admissible under the Texas Rules of Evidence at a trial held on the date of the application. And finally, the court would have to find that if the scientific evidence had been presented at trial on a preponderance of the evidence, the person would not have been convicted. Okay. Now, that did not go far enough. So 2 years later, in 2015, we passed another law and said the courts would now consider whether the field of scientific knowledge, not junk science as we conveniently refer to it, we would now refer to it as the field of scientific knowledge had changed. The court would also have to consider a new item, whether a testifying expert's scientific knowledge had changed. And so we created those standards. And what I'm trying to get to, did we go far enough or did we go too far? For example, it bothers me that the Court of Appeals seems to be taking a higher standard. They say that the evidence must reflect that the accused would be innocent. I don't think that's the standard by which we anticipated or created in 2013 and 2015. This almost, and several of the witnesses, I think they're going to testify again today, it's almost as though this habeas trial, it's kind of like a game of football. You're going to win or lose. I mean, instead of trying to determine, in your words, the goal is to seek justice, it doesn't appear that the functionality that we've created in the Court of Appeals is designed to seek justice, or is it simply designed to see who wins and loses? That's what's bothersome to me. Have we created language that would suggest the Court of Appeals is saying, no, that evidence has to show the accused is innocent, when I don't think when we voted for this bill in 2015, 2013, that was a level of examination that I don't think we created. So I guess ultimately I'll come to a question. The question is, do you think that our current law for scientific knowledge has changed, and whether or not we had an expert testify, not changed his testimony, saying that he believes he wasn't innocent. I mean, he wasn't guilty. Do you think our current, and I've given you the factors that compose what we're trying to address here, is that science has changed. Do you believe that we followed that law, or the Court of Appeals has followed that law? And if not, what should we include in statute that will assure that following?
Well, I can answer that. Can I answer that in two parts?
Sure.
One is, I think it needs, whatever it is, needs to be followed evenly. I believe it's the Roark case that last week or the week before, a new trial was granted, correct? But in this one, it's not. So, I mean, it seems to me like it needs to be evenly applied. So I'm wondering, how do you explain that to Mr. Roberson's family? And then secondly, I think there's some simple language that might help. And now, I'm not a lawyer. I don't mean to brag, but I'm not. If you added something to it that said, in the event the filing is on behalf of a convicted person to be executed, the court shall stay the execution and grant the convicted person a new trial if the relevant scientific evidence was not available to the convicted person in light of his or her circumstances, and or that relevant scientific evidence contradicts scientific evidence relied upon by the state at trial. So if it's evolved and it wasn't available at the time, they ought to get the best science available that bears on their conviction. it seems to me when they're executed for a long time. And you see something as clear as the case I cited earlier about Mr. Byrd. It took from 97 to 2019 to execute one of those perpetrators. In a circumstantial case, how can you not justify saying science has evolved? They get the current science, which is what this says, and I'm happy to share this if anybody wants it.
Okay.
It just says they get the current science.
Well, thank you for your testimony.